Good afternoon, good evening, and welcome. My name is Beth Marsh, and I am the Director of Membership and Stakeholder Engagement for the Organization of American Historians. Tonight's program is part of our Future of the Past webinar series. Our webinar tonight is also a joint project with the Immigration and Ethnic History Society, IEHS. The IEHS was founded in 1965 and promotes the study of the history of immigration to the United States and Canada from all parts of the world. The IEHS publishes the Journal of American Ethnic History. Our host this evening is Torrie Hester. Torrie is an associate professor in the Department of History at St. Louis University. Her book, Deportation: Origins of U.S. Policy, examines the national and international origins of U.S. deportation policy. And with that, I'm going to turn it over to Torrie and our panelists. Thank you so much for joining us this evening.
Thank you, Beth. It's an honor to be part of this panel. I'm going to introduce our speakers all at once. Then they'll each deliver some comments and engage in some discussion. After about 35 minutes or so, we'll open up the session for about 20 minutes of questions. So here are our panelists. Amanda Frost writes and teaches in the fields of immigration and citizenship law. Her scholarship has been cited by dozens of state and federal courts, including the U.S. Supreme Court, and she's been invited to testify by both House and Senate Judiciary Committees. Her non-academic writing has been published in The Atlantic, The New Republic, The Washington Post, and The New York Times. Her last book, entitled You Are Not an American, Citizenship Stripping from Dred Scott to the Dreamers, was named a new and notable book by the New York Times Book Review and was shortlisted for the Mark Linton History Prize. She's currently at work on a book on the history of birthright citizenship to be published by Simon & Schuster in 2006. Beth Lew-Williams is professor of history and director of the program in Asian American Studies at Princeton University. She is the author of The Chinese Must Go, Violence, Exclusion, and the Making of the Alien in America. And her new book, just out this year, is John Doe Chinaman, The Forgotten History of Chinese Life in America, American Racial Law. Lew-Williams has held fellowships from the National Endowment for the Humanities, Harry Frank Guggenheim Foundation, and the American Council of Learned Societies. At Princeton, her teaching was recognized by the Phi Beta Kappa Teaching Award. Madeline Hsu, our third panelist, directs the Center for Global Migration Studies at the University of Maryland. Her award-winning books include Dreaming of Gold, Dreaming of Home, Transnationalism and Migration Between the United States and South China. Another award-winning book is The Good Immigrants, How the Yellow Peril Became the Model Minority. She has co-edited A Nation of Immigrants Reconsidered, U.S. Society in an Age of Restriction, 1924 to 1965, and Volume 2 of the Cambridge History of Global Migrations. She is currently researching immigration and citizenship regulation in decolonizing Singapore and Malaysia. Our final panelist is Anna Pegler-Gordon, who is a professor at Michigan State University, teaching in the Asian Pacific American Studies program and the James Madison College, an undergraduate residential college specializing in the interdisciplinary study of public history. Her books have focused on immigration policy, including Closing the Golden Door, Asian Migration and the Hidden History of Exclusion at Ellis Island, and Inside of America, Photography and Development of U.S. Immigration Policy. Her current research focuses on everyday Japanese American resistance to curfews, travel restrictions, and registration during World War II. Amanda, the floor is yours.
Thank you. I'm really looking forward to the conversation that we're about to be having. And my job tonight is to very briefly provide some context to the debate we're having as a nation and, of course, to the discussion we're about to have here. So the context or background begins, of course, with the U.S. Constitution, which initially did not define citizenship. It referenced citizens as a prerequisite to serving in Congress or a natural-born citizen to be president of the United States, but didn't define who was a citizen. So, of course, that brought us eventually as a nation having many a debate about this question of who counted as an American, particularly in a nation with both Native Americans and racialized slavery. That brought us to Dred Scott, which I'm sure everyone listening is familiar with, but I'll just repeat that one holding of that case was that no Black person, slave or free, could ever be a citizen of the United States. Congress had no power to change that. And I'll also add, and I think it's overlooked, that Dred Scott, Chief Justice Taney, in any case, writing for at least some of the court, said also no one of a subordinate or inferior class could be a citizen. And I'm certain he meant to extend that beyond Black people, of which he explicitly included. Who would have been excluded from citizenship is anyone's guess, but I think it would have been a large categories of people if Chief Justice Taney and those who thought like him had their way. So, of course, we fought a civil war over slavery, and at the end of that war, we had ended slavery, but it was not clear who was a citizen, and the Reconstruction Congress knew it had to deal with this problem. So in 1866, they debated and adding language to what became the 14th Amendment to the U.S. Constitution. And they actually didn't debate it for very long, and a couple of our panelists will address this in more detail. But what they discussed was the need to overrule Dred Scott by establishing a rule of universal birthright citizenship and creating a clear and bright line, easily administrable rule that could not be second guessed by courts, because, of course, they had the Dred Scott history that they certainly didn't want to leave this to the courts or the executive at that time, Andrew Johnson, not a friend of Reconstruction. So they added as that first sentence to the 14th Amendment, the citizenship clause to the Constitution, which reads, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state in which they reside. So that key question is, well, what does it mean to be subject to the jurisdiction of the United States? What does that mean? What is that language referring to? So the Reconstruction Congress, in its very short debates on this, made clear that it would exclude children of diplomats, which of course makes sense as a matter of policy. It was also a longstanding exception to the English common law rule of birthright citizenship that many thought the U.S. had inherited before Dred Scott. And in addition, they debated at more length what happened to children born within Native American tribes. And they decided to exclude those individuals as well, using that subject to the jurisdiction thereof language. And finally, children of invading armies occupying the U.S. were excluded, although happily we have not had that situation. So the Reconstruction Congress also referenced immigrants and made it clear they wanted to include the children of immigrants. And again, others on this panel will go into more detail, but they referenced that, and that was part of that debate. So then there was, of course, the post-Reconstruction era, where a lot of Reconstruction values and a lot of the constitutional principles were eroded. The executive branch, in particular the Solicitor General of the United States and the Attorney General, decided to challenge universal birthright citizenship. They wanted to bar it for children of Chinese immigrants in particular. That's clear from the archives and their letters. Lucy Salyer's done some great work on this to bring that to the fore. But at the end of the day, they brought their case to the Supreme Court in 1898, and it was a close call, I think, but the government lost. And so the court repeated what the Reconstruction Congress had said, what the text says, which is that everyone's a citizen with those narrow exceptions for the children of Native Americans and the children of diplomats. And then we had nearly a century of agreement about that question until January 20th, 2025, when, of course, Donald Trump became president. He promised to do this, and he did it day one, and within a few hours of taking the presidency, where he issued an executive order that declared not what he thought was a new interpretation. He said, this is what the 14th Amendment has always said, which is that there is not near universal birthright citizenship, but rather accepted from that subject to the jurisdiction thereof exception, falling within it were children born to undocumented immigrants and children born to temporary lawful immigrants. So people estimate that's about 300,000 people a year who would be born in the United States and excluded every year from citizenship. In addition, every single American having a child would now have to prove their lineage to the government's satisfaction to ensure that their child is treated as a citizen. That was immediately enjoined in a number of lawsuits. Those lawsuits are ongoing. They've reached the courts of appeals. There's now a class action that's been certified. So the executive order has been enjoined unless and until that class action is decertified or the Supreme Court gets the merits of the case and reverses. I will say that there's expectation, no guarantee, because we never guarantee with the Supreme Court, but there's an expectation this case will reach the Supreme Court likely in the spring of this year. And I'm happy to talk at more length about the litigation or any of those issues. But now I'll turn it over to my fellow panelists.
Thank you. First, I just want to say thank you for hosting us, and thanks to the OEH for hosting a conversation about a really urgent topic today. I also think Amanda teed me up there wonderfully, because what I thought I would talk about was sort of the two classes of immigrants that the Trump's executive order are sort of calling out and trying to argue should be accepted from the principle of birthright citizenship, right? So what Amanda just said is that the Trump's declaration is trying to single out temporary immigrants, temporary lawful immigrants, their children, and the children of undocumented immigrants. And they're trying to do this, though the sort of logic, the argument is that this is based on the phrase subject to the jurisdiction thereof, right? Because the Citizenship Clause reads, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. And though I think a lot of these court cases are becoming an argument over original meanings. What did Congress intend when they drafted the Citizenship Clause of the 14th Amendment? And I think that this question is difficult, actually, and it's difficult in part because these two groups are children of immigrants. But the children of immigrants was not the primary question before Congress when they were debating the 14th Amendment. As you just heard, they were primarily focused, I think, on granting citizenship to newly emancipated Black people. And many of them were very focused on continuing to deny citizenship to Native people who were living outside of America's jurisdiction. So one of the reasons that it's difficult to go back and think through original meanings is because it was not the primary thing that Congress was debating. The other thing that makes it a little bit tricky is that there were not yet undocumented immigrants the way that there are today at the time of adoption of the 14th Amendment. And that's because there were many of the major federal immigration laws are after this period. So the Page Act regulating Chinese and Japanese women, Chinese restriction, Chinese exclusion, these laws that would start to produce the first unauthorized immigrants in large numbers, the first undocumented immigrants in large numbers, had not yet been passed. But Congress did consider immigrants as they were debating, and they considered in particular two populations of immigrants that they saw at the time as undesirable. The first were Chinese immigrants on the West Coast, and the second were Gypsies or Roma people that were also considered highly undesirable at the time. And so as we look at or try to contemplate the original meaning and what Congress had to say about temporary immigrants or about unauthorized immigrants, we have to look at the arguments or the conversations that they had, the debates they had around Chinese immigrants and Gypsies. And I think there we find some really compelling evidence that both of these groups were understood to be included within the Citizenship Clause, that their children would be U.S. citizens by birth. So this is true for the Chinese, even though senators understood the Chinese to be, many of them, to be temporary immigrants, and they were understood to be undesirable. And so I look in particular at the words of Senator Conness, who was a senator from California, and he sort of in his speeches, he explains that Chinese immigrants, he says, quote, all return to their own country at some time or other, either alive or dead, right? He says those persons return invariably, others take their places. So he sort of describes the Chinese as these temporary immigrants. And at the same time, he argues that they should be included under the Citizenship Clause. So despite the trepidations about Chinese immigrants into California, Senator Conness makes clear that he's in favor of the Citizenship Clause, as he had been in favor of the citizenship provision of the Civil Rights Act. And he asserts as part of this debate, he says the children of all parentage, whatever, born in California should be regarded and treated as citizens of the United States, entitled to equal civil rights with other citizens of the United States. I think this is one of our clearest moments where we can say the Senate discussed an undesirable immigrant group, an immigrant group understood to be temporary, and affirmed that the citizenship clause applied to their children. A similar thing happens around debates around the Gypsies, or Roma people, so Gypsies at the time were described in really highly racialized language as being undesirable. They're described in the course of debates as invading the United States, as trespassing, as having no allegiance to the U.S. government. And despite these descriptions, which I think today evoke the same rhetoric that is often spoken around unauthorized immigrants or undocumented people, the Senate debates make clear that the senators expected the citizenship clause to include Gypsies. And I think one more point I'll just make on this, although it's a bit of a digression, is that in the rhetoric around Gypsies, the senators sometimes describe this as an invasion. They describe Gypsies as invading the United States. And there's a back and forth about this as well. And Senator Khan kind of talks about, but these, he sort of calls out the Pennsylvania senator who describes Gypsies as invaders. And he says, this is not really an invasion. The only real invasion that has happened recently is the invasion of Confederate rebels into the North, right? So he sort of calls out that even this nativist rhetoric that describes immigrants as invaders is really just rhetoric, right? It does not fall under that narrow exception for the children of invading armies. So what I wanted to do was sort of dive deep into the way that the Senate was discussing immigrants at the time. And I think we could back up and talk about whether originalism should be the center of our court decisions. But I think since our Supreme Court at the moment has made it so, it really makes clear how important historical work is in this current struggle over birthright citizenship. And I was really struck, listening to Amanda, and I think you'll be struck listening to our other speakers, how many different fields intersect in this history and are contributing towards our understanding of birthright citizenship, right? So it's folks working on citizenship, but also folks working on Reconstruction, on African American history, which has a large strain here, Asian American history, immigration history, legal history, right? All of these fields play a role in the current day cases challenging the president's declaration. With that, I'll hand it over.
Thank you. This is such a wonderful experience. I could actually just sit here and listen to my fellow panelists and not say anything at all. But thank you. Thank you, Amanda and Beth, for setting this up. Such sort of deep historical knowledge and situated in larger pictures. I thought I would take the tack of just discussing some broader principles regarding allocation of citizenship. And so just to understand that there are contradictory principles that can be applied. And so here we're focusing on birthright citizenship, or jus soli, which if you sort of look at the pattern of which countries, contemporary countries, now have birthright citizenship, most of the countries in the Americas have had birthright citizenship. There's only a few other countries in the world that have unqualified birthright citizenship. And so when we think about the United States in that regard, the United States actually has very liberal policies. Jus soli, birthright citizenship, can be understood, as Amanda described so adeptly, as really seeking to be inclusive, to enabling populations in place to be able to settle, to participate fully. This was also the case for many of the countries in the Americas. And in my discussion of sort of the Americas more broadly, I'm drawing heavily on culling the masses, the racist origins, the democratic origins of racist immigration policy in the Americas by the historical sociologists David Scott Fitzgerald and David Cook Martin. And they point out that unlike the United States and Canada, and also Haiti, most of the countries in the Americas, upon gaining independence, very quickly moved to regulate citizenship. And their policies were inclusionary of all populations within their territorial boundaries, right? And this means that most of them prohibited slavery almost immediately, acted to include Black persons, Native populations, alongside European settlers within the parameters of citizenship. Following up on this, they proceeded to have racially discriminatory immigration regulations. So they were not sort of free from racial preferences, but this also helped us to situate jus soli, birthright citizenship, as an effort that affirmed many of these countries' efforts to recruit European immigrants, right? And to persuade them not only to come to settle, they really needed what were seen as the most suitable kinds of population to help develop them economically, to come and then be able to gain citizenship and to make a commitment. So this is the United States was the most successful, actually, in attracting immigrants, did not need to use these same kinds of policies to recruit immigrants. The U.S. undertakes birthright citizenship for a very different set of purposes and under very different conditions, which is this desire really to be able to include African Americans after the ending of slavery as an institution. I also wanted to just throw out there are competing principles of citizenship. So another very powerful way of and the divide between those who can become citizens and those who are barred from citizenship is just a stark divide. And I think it's important that as we process and think about what our policies, the very different kinds of rights and access that our policies produce, that we need to acknowledge this. Dissent or jus sanguinis principles are also very powerful, right? And the belief that, of course, parents should be able to transmit onto their children their citizenship. We also have, and I guess this is in the 14th Amendment, naturalization. And the conditions and the parameters of naturalization, who can get citizenship by naturalization, is also heavily contested. We have moved on to a phase of national history in which legal immigration has been a key criteria for making the staking out the differences between those who can get citizenship and cannot get citizenship. And against those discriminations, birthright citizenship has been a major toehold. So people who have been able to come, who have made lives, at least through U.S.-born children, are able to try to establish more stable roots. So I just thought I would put this out there, maybe contribute to the conversation, and I will hand things over to Anna.
Thank you, Madeline. So I plan to discuss briefly both Wonkimark, the person, and then Wonkimark, the decision. Wonkimark was born in San Francisco in 1873, 4 years after the 14th Amendment. So he was born into U.S. citizenship, and his parents were Chinese immigrants and Chinese nationals. They did not work for the Chinese government, which was something that was cited in the decision, but they were aliens and eligible for naturalized U.S. citizenship. And they were domiciled in or residents of the United States. And this was actually interesting, Beth, when you were speaking, because I did remember that, and Justice Gray actually says that they were, who wrote the majority opinion in the decision, wrote that they were permanently domiciled. And that actually made me think, oh, that may have been something that he was sort of emphasizing and sort of contra the sort of sense that it was temporary residence. Like many Chinese immigrants and Chinese Americans, Wong Kim-ark traveled regularly between the United States and China. And when he arrived in San Francisco in August 1895, he presented his documents to the customs collector and applied for re-entry to the United States as a U.S. citizen. And this was not the first time that he had done this. And customs officials routinely examined arriving passengers of Chinese descent and the documentation to determine whether or not they were exempt from exclusion laws that had been implemented in the period, as Beth was describing, since the passage of the 14th Amendment. And in 1895, the among sort of people who were not U.S. citizens, but who were of Chinese descent, that would have been diplomats, merchants' wives, children, and household staff, as well as students and travelers, who were coming temporarily, who were allowed to enter the United States. And of course, though U.S. citizens were also allowed to travel to and from the United States. And after the passage of the 14th Amendment, individuals of Chinese descent born in the United States should have been clearly understood as U.S. citizens and therefore exempt from both immigration and exclusion laws. However, their claims of U.S. citizenship were subject to the same investigation processes, very extensive investigation processes as non-citizens. They were interrogated, their families and colleagues were interviewed, their documents were inspected. And it's important to note that this was rarely required of European immigrants or U.S. citizens of European descent. So when Wong Kim-ark arrived, he actually had quite a large case file containing evidence of his previous travels, as well as his return certificate, an affidavit testifying to his birth in San Francisco that had been typed up prior to his departure and signed by 3 white witnesses, even though 2 were required by customs officials. And that was probably because he had previously had his documents interrogated. But in 1895, officials acknowledged that his documents were all straight. That was literally a quote. They were all straight. But they claimed that Chinese born in the United States were not citizens. And so the link between his birth in the United States and his documentation wasn't questioned, but it was the link between his birth and his citizenship. I think that there's no question, right, as Amanda pointed out, that the people we're discussing at this time or today were actually born in the territory of the United States. The question is, are they restricted by jurisdiction? Are they subject to the jurisdiction of the United States? And Justice Gray, writing for the majority, ruled that immigrants are subject to U.S. jurisdiction, even those who are not allowed to naturalize as U.S. citizens. And I think here also it may be worth flagging that while it is absolutely true that at the time of the passage of the 14th Amendment, there wasn't, a sort of category of unauthorized immigrants because the laws that made people unauthorized hadn't been enacted. By the time of the Wong Kim-ark decision, the customs officials were routinely emphasizing that, that Chinese immigrants were entering the United States unlawfully as immigrants and also as U.S. citizens under, the guise of U.S. citizenship in their opinion. And so I think that's an important context as well, is that the context of the moment in which that decision was made. I would just say, despite, so there was ruled that immigrants are subject to U.S. jurisdiction. Also that Congress can enact Chinese exclusion laws that restrict the entry, that deport or disallow the naturalization of immigrants. But these do not apply to citizens. And immigration and exclusion laws are subordinate to the Constitution and they cannot violate the Constitution. And so therefore, based on this decision in 1898, ethnic Chinese, other Asian individuals, and almost all individuals born on U.S. soil secured the right to jus soli, birthright citizenship, in the way that we've discussed. This is a vitally important ruling, and it is settled law, as most people accept. But being settled doesn't mean that it was being settled in the law doesn't mean that it was settled in practice, right? It's really important for us to remember that even after this ruling, U.S. citizen arrivals continue to be subject to the same investigations as arrivals who claimed exempt status. They had secured citizenship, but they couldn't secure recognition of their citizenship without documentation, which at the time, birth documentation was not extensive. That was the key that linked birth to birthright. And I think this is really telling in terms of what Amanda said also, that, this executive order, were it to be accepted, would reopen that question of documentation in the most extensive and concerning way, in a way that hasn't really been seen for about a century. So thank you very much.
Torrie has asked me to jump back in to address a couple of the questions in the Q&A, and I'll just add my thanks for OAH organizing this, and it's a pleasure to be here and learning from the panelists. I'm going to follow up with you all because I'm writing a book on this. But in terms of just one point I wanted to make, and then a Q&A question that Torrie asked me to respond to. The point I wanted to make was that reference to, were there undocumented or unauthorized immigrants in 1866 when the Reconstruction Congress was debating the language of the Citizenship Clause, and the nation then voted to ratify it. And while certainly we didn't have the host of laws we have today limiting immigration, there actually were laws that barred people from arriving in a couple of different key contexts. One was the unauthorized slave trade. Congress had barred the slave trade in 1808, and legal scholars like Jerry Newman at Harvard and Jack Chin at UC Davis have done extraordinary work in really digging this up. This was a topic of conversation and public debate. Congress passed laws saying you can't import enslaved people from outside the U.S. People nonetheless did. There were laws about penalizing the importers. There were laws about removing the unauthorized slaves. So that was a topic of conversation, well known. And in addition, states had laws that barred people from coming in based on poverty or illness. So it wasn't foreign to the Congress or the people of the United States to think some people were here without permission. And I think that's important because the Supreme Court thinks original understanding is important, and they knew about it and didn't exclude these groups. In fact, it's very clear that the group they most wanted to include were all of the enslaved people. So now to turn to one of the Q&A questions about the Indian Citizenship Act of 1924. So as we've all discussed, this Birthright Citizenship Clause in the Constitution creates an exception for those who are, quote, not subject to the jurisdiction thereof of the United States. And the debate included children of diplomats. Diplomats obviously have immunity. There's a fiction they're not fully in the U.S. Embassies are foreign soil. And Native Americans were separate, at least quasi-sovereign entities. I'm not saying the U.S. respected that with great frequency, but that was the idea. They had that discussion that children born within Native American tribes had their own courts, had their own laws, and they were not fully subject to the jurisdiction of the United States. So they were excluded from birthright citizenship. There was actually a case, Elk versus Wilkins, at the end of the 19th century on this issue. The Supreme Court affirmed children born within tribes, not children who are Native American descent necessarily, but those born within tribes are excluded. And then it's important to add that by statute today, all children born within Native American tribes are citizens. That's the 1924 Indian Citizenship Act that changed the law there. It has got a fascinating history all of its own, which we don't have time for me to cover, and I'm not the right person anyway. But if you're interested, Bethany Berger, among others, has written great scholarship on this.
I'll just piggyback onto that. Just this is general context that during the 19-teens and 1920s, there's just a slew of court cases in which there is a sorting out of, according to race, which people from what parts of the world can actually get citizenship. So the key dividing line still at this time is whether or not you can be considered white or Black. And so Asian immigrants, many made a stab at claiming some version of whiteness, testing that divide. We have the landmark cases of Ozawa versus U.S. and then also Thin versus U.S. And both were denied citizenship. Ozawa because racially he was considered non-white, and Thin, who was Asian Indian, and Asian Indians actually are categorized as being Aryan or Caucasian. And there had been a few dozen Asian Indians prior to Thin who had been able to apply for and gain citizenship by naturalization. But with Bhagat Singh Thin's case, which was decided by the Supreme Court in 1923, the Supreme Court reverses this and also contradicts its own racial logic in the Ozawa case, which was handed down the year before, in determining that Thin, in the eyes of the common man, and this is the language the court used, would not be viewed as white. Therefore, for purposes of citizenship, he could not. His application was going to be turned down. There's also a slew of other cases that are decided. For example, Armenians, Syrians. There's also increasing pressure for people who have been resident in the United States to go ahead and proceed with naturalization. And so there is sort of hardening lines of enforcement. Look, we have the 1918 Act that starts requiring people to carry around passports. In the 1920s, there will be the onset of requirements that people get visas to verify that they're authorized to enter, right? And so when we talk about undocumented, right now it's a very powerful system of tracking of persons who don't have lawful entry or who have exceeded the terms of their lawful entry. But all of this still had not yet really been developed in terms of being able to document, to categorize. This is all starting to happen with the anti-Chinese laws.
I'm happy to jump in to partially answer one of the questions that we got from Brendan Shanahan, who's asking about whether the attempts to circumscribe birthright citizenships are tied to other efforts, right? Efforts to denaturalize immigrants or to expatriate Native people or to affect people's freedom of speech or freedom of dissent. And I don't know on all of these categories, and so I invite our other panelists to jump in on this question. But I did want to highlight the work of Hardeep Dhillon, who has a piece that's going to be coming out with Modern American History later this year, in which she does a very she pulls out an important linkage between voting rights and birthright citizenship. She found that the officials who, stopped Wong Kim Ark at the border and questioned the Chinese access to birthright citizenship, that those same officials were deeply concerned about the Chinese vote by enfranchisement. And so I think that that's something where we can see that that fears around political power is historically something that inspired this sort of questioning of birthright citizenship. And I think that we see similar fears in the current day around voting and immigrants' children. And so it's one of those ways in which these conversations about birthright citizenship are actually conversations about lots of other things.
And I'll just jump in to say quickly that I wrote a book called You Are Not American with chapters on all of these phenomenons, because I do think they are tied together. And I think the Trump administration today, you can see the connections, right? Because there's, for those who don't know, was an effort in Trump 1 and again to denaturalize large groups of people, to investigate, to see if there's any errors or fraud or problems in the naturalization process, and to denaturalize. And this was something they're very explicit about as an immigration enforcement tool. And I think it is connected to the idea of redefining who's a citizen and to using speech as a potential way to deport either non-citizens or to denaturalize citizens. I can recommend a book called Threat of Dissent, which I don't remember the author's name, but it talks about the history of using immigration law to suppress speech critical of the government. And I recommend that book as well.
Julia Rose Kraut. I think I will sort of introduce the the history that populations that had been excluded from citizenship, Native Americans, and then also free Blacks, historically were, I think, seen as incompatible with physical presence in the territory of the United States, right? And I think so many of our struggles of around excluding certain populations from citizenship, but then also trying to exclude certain populations in terms of immigration regulation goes to this ongoing struggle, which I don't know that it is, in fact, something that can be realized, of aligning sort of preferred populations with our physical territory over which we have sovereignty. And so hence the placing of Native Americans into their native nations, right? And this kind of fiction that they have a separate citizenship, a separate nationality, territorially, this attempt to isolate them. There's also parallel efforts to encourage free Black persons to leave the United States, right? So we have the American Colonization Society, which I think is established in something like 1813, because in a slaveholding republic, as Kevin Kenny has talked about, to have free Black persons existing alongside enslaved Black persons, it's a unsupportable contradiction, right? And so this is, some of the efforts to denaturalize, the efforts to expatriate, the efforts to deport, is that there are certain kinds of people who are targeted, and their physical presence in the United States is irreconcilable with the policy goals we have enacted.
Yeah, and just building on what Madeline said, I wanted to emphasize the way in which the Trump administration is really leveraging Indigenous people against temporary immigrants and undocumented immigrants. We discussed the Elk versus Wilkins decision, which really punished Indigenous people for maintaining or attempting to maintain as much sovereignty as possible by removing citizenship under this category of subject to the jurisdiction, and really arguing that they can only have one citizenship. And I think this raises some interesting questions about dual citizenship under potentially this executive order. But it just to flag that the Trump Justice Department, this is a quote from a press conference, that the United States connection with the children of illegal aliens and temporary visitors is weaker than its connection with members of Indian tribes. If the latter link is insufficient for birthright citizenship, the former certainly is, right? And it's very clear that many Indigenous nations have come out very strongly against this leveraging, and the fact that they sort of have received under the 24 Indian Citizenship Act sort of only statutory citizenship, birthright citizenship, that in fact that this is to use their status in this way against other groups is really enraging.
Yeah, in my recent work, I've been thinking more about the importance of citizenship for Chinese immigrants at the time. Well, not immigrants, but their children, and the distinction between the lives that were possible for immigrants, Chinese immigrants, and Chinese Americans, Chinese born in America, or those with derivative citizenship. And I think that one of the things that historians have spent a lot of time talking about, like what is that distinction between an alien and a citizen? What are the legal disadvantages of alienage? We focused a lot on immigration, right? The ability to cross borders. And certainly this is an incredibly important right that comes with U.S. citizenship, to enter the United States, to remain in the United States. And that's still true today. But in my recent book, I've been looking more at local laws. And since Brendan Shanahan is asked us a question, I know he's here, but he has also, in his new book, Disparate Regimes, looking at alienage laws at a local level. And I was particularly interested in the laws that affect the Chinese on the West Coast. And I think if we look really closely at these laws that designate citizenship privilege or the disadvantages of alienage, we get a sense that it's not just the moment of border crossing in which this distinction has a import import for people's lives. In the 19th century, there were so many laws around, that regulated the ability to do things like own land, to hunt or to fish, what taxes you had to pay. There's laws that affected ability to seek education, or access government records, or serve on a jury, or serve in a public office, or be a school teacher, or get books out of a library. Like, all these things are around citizenship privileges. And I think that it's important to think through all of the local statutes and laws to really get a full picture of the importance of this legal distinction.
So there was a question about statelessness that was in the chat. So I thought I would just respond and briefly and say a couple of points about the Trump executive order and its relationship to the potential for statelessness. So if it were to go into effect, and of course it said it would go into effect 30 days after he took office, and it's only been enjoined by courts because of litigation. But if it were to go into effect, then every child born would, of course, the parents would have to prove lineage. And then for approximately 300,000 children, that child would be born without status in the United States, automatically deportable day one. Their parents would, in some cases, maybe in the majority of cases, be able to transmit their citizenship to the child through jus solis, which we've already had a discussion about, that citizenship by descent. But there are some countries in which you're not permitted to transmit your citizenship to a child born outside of the country. Of course, other people are here without their own separate citizenship, and that means the child would be born stateless. And I think the point here is, first of all, that would be obviously a terrible outcome for those children. But the second point to make here is every aspect of our immigration laws, and I teach immigration law, and there's like a code this thick. They all assume that everyone born in the U.S. is a citizen, because that's what the 14th Amendment says, and that's what we've assumed for more than a century. And our laws embed that concept. So we have no plan for what to do if children born in the U.S. suddenly are not citizens because of a brand new interpretation of the Citizenship Clause. And I'll add that this came up at oral argument in the Supreme Court, where the Solicitor General of the United States was asked by a justice, well, what's your plan for implementing this? You say it's going to go into effect in 30 days if we rule as you would like. This was a case heard in the spring on a procedural matter, but this came up. And he said, oh, we'll have to figure it out. Go look at the transcript. They have no idea how they would implement that. And I'm laughing that I shouldn't, because it would be both chaos and would put enormous numbers of people at risk and add enormous stress to all American families, all families having children in the U.S., not just immigrants. And I hope people feel sympathetic enough just to the immigrants. But if they don't, they should realize that anybody having a child going forward now has to prove citizenship for that child to be recognized, get medical care like Medicaid, be allowed to stay in the United States, get access to state and federal benefits. The impact would be enormous, and for stateless children, even more so.
Hey, to me, statelessness goes to fundamental issues about human rights. And, and there is just a very basic problem that human beings exist in space. They need to have a physical place to be. Beyond that, they should have rights to lives, to livelihoods, to be able to sort of live in some reasonable amount of safety and security. And we have laws, national laws, that produce now millions of people around the world as refugees, as stateless persons. It is, it's very difficult to understand and to justify this situation. I'll just say very quickly, because I can go on, that with some of the reason why I'm working on Singapore and Malaysia and their decolonization is that they are just a couple among the dozens of nations that emerge in mid-20th century when there is just the hardening of national boundaries, a fortifying of citizenship qualifications. There are many places in which these issues are as yet unresolved, in which you have categories of people who suddenly find themselves without legal rights to remain, to make lives in places in which they have already established themselves. They're also not permitted to go back to ancestral homelands. There is just significant issues of displaced people without sufficient sort of claims to a particular territory. And I understand the crisis in Israel and Gaza in this light. And so it is, if what the Trump administration is undertaking to do goes through, we are just, for no good reason, creating these kinds of just sort of dire undermining of just sort of basic human rights.
So there's a question in the chat that says, this seems like a slam dunk. What are the sorts of things that I guess that the administration might focus on in court? I mean, my experience is that they like to sort of add what is not there into this clause. For example, arguing that to access birthright citizenship, your parents must be in allegiance to the United States. Of course, the clause does not actually state that, but they sort of try to add this as an additional criteria, or they add the idea of domicile, that an immigrant must be domiciled in a long-term way in the United States, not simply in residence. Again, that is not stated in the citizenship clause. And so, yes, I think this is a slam dunk. I think it is very clear that the 14th Amendment includes all of the children of immigrants who are born here in the United States. And I'm hoping that the Supreme Court will affirm this already settled law.
I guess I'll just add two really quick points. One is when we're thinking about the original understanding or meaning, in addition to all the discussions we've had about who was intended to be excluded and all the people that were intended to be included, it's also very clear that the Reconstruction Congress intended to create a clear, bright line, easily administrable rule. That is a self-executing rule of citizenship that did not require a court to weigh in, didn't trust the Supreme Court for good reason. Dred Scott was in the recent memory. Certainly didn't trust the executive, Andrew Johnson. And they said, we have to fear and be aware that our government could fall into hands of people that do not think like we do. And we need to put a very clear rule in our Constitution. And it has been viewed as very clear for a century. It's only now that it's muddied. I should say, I think it's a slam dunk in the sense that I think all the law supports the conclusion that it means what it's always been understood to mean. But that doesn't mean that there wouldn't be votes against this. I would count 2 or 3 people on the Supreme Court right now, justices who would carve out undocumented immigrants. I think it's possible to fall. There's never, to me, the story about what the law is and what it means and how we interpret it. It's always contested in the public sphere. It's never left entirely to justices. And I will never rest easy on this front, especially not right now. Very quickly, the last thing I'll say is that the children of immigrants have been an enormous benefit to the United States, and we have integrated them better than just about every European country. We don't do a lot better than them, but we do that better. And I think partly that is because of birthright citizenship. Just another reason to keep it.
So I've been requested to sum up, and I just want to say that my brilliant colleagues on this panel really underscore what Beth put so eloquently, that understanding history in an empirical, developed way is so critical as a tool to understanding our present, to engaging with the current political crisis that we find ourselves in. And I think, the Congress that enacted the 14th Amendment, the various courts that evaluated it and made decisions, understood that we are a democratic society, and a democratic society embodies and finds ways to enable people to coexist, to share our political systems, to share our society, to share our territory across many, many kinds of differences. And this is what the founders hoped to develop. They may have had a somewhat narrow vision, but they really did put guardrails in place to try to foster a new kind of much more egalitarian political system and society. And what is under attack now is this effort to restrain, to silence voices, to reduce the kind of diversity that, in fact, has been such a cornerstone of the greatness of this country. And so, birthright citizenship, as Amanda stated, has been such a key strength in terms of enabling this country to realize this potential and this kind of this amazing set of possibilities.
I think on that note, our time is rubbing to an end. I wanted to thank all the panelists as well as everyone in the audience. That was just fantastic. Thank you very much.
Thank you all. This recording will be available on our YouTube channel mid next week. And I also do want to let you know that we have 2 more co-sponsored webinars with IEHS that will be taking place next month, and we will be announcing those shortly. Thank you.